Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about something that's very close and very new, is litigation cases relating to AI. Now, one of the main things at the moment is a court case in the US between Anderson and Stability AI. Stability AI is the company responsible for products like Stable Diffusion, which is a product that it's an AI system where basically you can type in a query and you'll get generated illustrations or photos. Now, the problem is that Stability AI trained their system with over 100,000 gigabytes of visual information they poured into the system to train it. Now, what the court in the US is looking for at the moment is whether that is actually an infringement of copyright. Now, this is very different to previous things that have come up before where court cases have looked at specifically whether AI systems trained on text-based sort of learnings are a copyright infringement. This is more of to do with the visual graphics and photos and images. Now, the problem is that those are processed very differently to LLM models, language models. Basically, what it's doing is it's taking images and making them look very similar to the original work. So some of the similarities are a lot closer than what would be under a text model because the outputs are completely different. So what they're looking for at the moment, this case is going through California court in the USA. And at the moment, Stability AI filed a dismissal for the actual court case. The dismissal was discharged because the judge found that there was 4 main areas that didn't really fit with the previous AI decisions that have been out there. The first one was that the judge didn't believe that there was a previous technology that was similar to this. So, and in the court case, they talk about VCR technology, copying images and that sort of thing. And yeah, of course, it's not the same as VCR technology. So the judge is automatically, and quite correctly, he wants to investigate this further. The second thing is they also want to have a look at whether you can make a copyright information claim against the makers of Stability AI. And this is kind of it's very tricky to prove that, and he's not talking about the copyright per se, but what he is talking about is the information that underlies the copyright. So the idea of the copyright, which is not something that copyright usually protects. The other things are that Stability AI has also made assertions that the portions they've copied are things that are not subject to copyright. And this is kind of a hard argument to run as well, right? Because a bit like if you made a cake and you poured all your ingredients in, mixed them all around and baked them up. How do you pull your sugar out? How can you say that that bit's unprotected, but that bit is? It's very hard to pull it all apart and deconstruct the whole thing and work out which bits are which. The final thing that the judge made a decision on was whether past decisions had any impact on this current case because of the large language models. And he said no. He thinks that this is a unique case in itself and it should be tried by itself. In this particular case with Anderson versus Stability AI, I think it's a watch and see case. So we'll see what comes out. They're basically going into discovery and the judge is looking at this from what's called de novo, which means new. So it'd be interesting to see what comes out. If you need any more information about AI cases or where the law sits in relation to copyright, please feel free to contact myself or the team at Alder IP. I'm more than happy to help you out. Thanks for listening.